Good evening, ladies and gentlemen, of course, the residents of Parsippany. I'm your mayor, James Barbario, and I have allergies, so excuse me one second. First, I want to welcome you tonight for the forum that we're going to have here on affordable housing. But before I get there, I just want to tell you, the town of Parsippany has been doing very well. Things are running very well, but I got to tell you, we were ranked the 5th best place to live in the United States. And we have increased our ratables in Parsippany, and things are going very, very well. Excuse me. Sorry. And I have to tell you,
it shut off again. That might keep on shutting off.
Turn on the wireless. I mean the new one. Turn on the new one.
Okay.
well, I'm going to have to yell like this here because it's not working. That being said, we have challenges here in Parsippany. And one of the challenges is the Council on Affordable Housing, which tonight I have with me former mayor of Rockaway Township, former freeholder from Morris County, Johnny Lucino, and our township attorney to educate the public here in Parsippany on what would happen, what might happen, and what might not happen. So, John.
Thank you, Mr. Mayor. Mine works. Good evening, everybody, and thank you very much for attending. As the Mayor indicated, my name is Johnny Lucino. I have about 30 years of experience in municipal government. As the Mayor indicated, I'm called Mayor Lucino, I'm called Freeholder Lucino, Attorney Lucino, I've been called other names, which are probably not appropriate for me to share with you this evening. But suffice it to say that I've been living with the affordable housing issue for decades, both as a policymaker, as a mayor, as a practitioner, as an attorney. And so it's not a subject matter that I'm familiar with. And tonight what I'm going to attempt to do is educate you on the affordable housing issue. I'm going to take you through the history of affordable housing in New Jersey and share with you how court rulings are impacting you in Parsippany and how they may impact you in Parsippany, so that there is clear understanding and information being relayed to you from the administration, so that you as citizens are informed. We have a slideshow here, and I will attempt to keep pace, but sometimes I don't, so somebody tell me if I'm getting behind. Affordable housing is rooted really in the concept of zoning. Zoning, of course, refers to government's power to regulate the use of your property. And it's a concept that I think a lot of you are probably familiar with. And the concept of zoning was actually first recognized and upheld back in 1926 at the federal level by the United States Supreme Court in the case of the village of Euclid. And at that time, the concept of zoning was relatively new, and most municipalities did not maintain zoning ordinances that controlled development. But the Supreme Court's holding in Euclid certainly contributed to the proliferation of zoning laws across the country, which have become really state law, areas of state law regulation. In New Jersey, being the most densely populated state in the country, was really and has been in the forefront of zoning laws. And so what happened was government was using its power in the eyes of some to use its zoning laws to exclude certain classes of people from moving into municipalities. So if we were back in the 1970s and we were nothing but farmland and we zoned our land all 5-acre zoning, it would be very difficult for people of modest financial means to be able to afford to live in a town that had, for example, all 5-acre zoning. Those folks would be excluded from the opportunity to live in that municipality. And it's that issue that really gave rise to the Mount Laurel decision. Now, picture what New Jersey was like back in the early 1970s. We had the aftermath of the Newark riots, for those of you old enough like I am to remember those days. We had also a suburban New Jersey that it was in its infancy in terms of its development. We had the greatest generation, followed by the baby boomer generation, who were at a stage in life where they were having families, getting married, and needed homes. And when you had that dynamic combined with urban flight, you had the proliferation of suburban New Jersey. And the feeling was that, folks in the urban areas were being denied the ability to participate in the good life of New Jersey's suburban municipalities. And it's really those dynamics that gave rise to the landmark decision of Mount Laurel, which was decided in 1975. And in that decision, the New Jersey State Supreme Court held that the state constitution requires each municipality to plan and provide, by its land use regulations, the reasonable opportunity for an appropriate variety and choice of housing, including low and moderate income housing, to meet the needs, desires, and resources of all categories of people who may desire to live within its borders. So this case put a proactive burden, an affirmative burden, on municipalities to zone in a way that would provide an opportunity for folks of low and moderate income levels to live in those municipalities. And in order to satisfy this constitutional obligations, municipalities, again, must affirmatively provide a realistic opportunity for the construction of their fair share of regional need of low and moderate income housing. Those words, fair share, regional need, went the wrong way, are words and terminology that are still very relevant today. Now, as you can imagine, this ruling by the Supreme Court was not very popular with the vast majority of folks in the state of New Jersey, and it certainly wasn't very popular with state legislators and with local governmental officials. The court, in its decision, essentially left it up to the state legislature to determine how to implement the court's edict. And the state legislature did what state legislatures do so often: they did nothing. And so that gave rise to the Mount Laurel II decision in 1983. And in that case, the Supreme Court affirmed its holding in Mount Laurel I and created a mechanism to enforce its mandate. And that mechanism is called the builder's remedy. The builder's remedy entitles a developer to a court-ordered zoning designation, including density, setbacks, building heights, lot coverage, green area, etc. I want you to think of the builder's remedy as a sword. It's a weapon that a builder has. And if a municipality has not met its constitutional obligation to provide its fair share of low and moderate income housing, then a developer can go to court and get an order from a judge that they're entitled to build multifamily housing anywhere in the township. Your zoning laws at that point mean nothing. A builder can build multifamily housing irrespective of what your zoning laws say. The township at that point loses total control of its ability to zone within its borders. It's a very, very powerful and, in my opinion, draconian remedy, and it is one that South Brunswick has recently suffered. So it is a remedy that is still available and still utilized by the courts. If a developer is entitled to, the developer is entitled to a builder's remedy if it does a few things. Number one, again, it has to succeed in the Mount Laurel litigation. It has to demonstrate that the municipality has not met its fair share burden. We're going to talk about what that means in a bit. And it proposes a project that has an affordable housing set-aside of somewhere between 15 and 20% of low and moderate income housing within the project itself. And they also have to show that the site is suitable for multifamily development. Suitability is a test in terms of whether the property is suitable. It has nothing to do with zoning. It has to do with the availability of water and sewer. What are the environmental conditions of the property? Is the property essentially buildable, and does it comport with general planning principles that would permit multifamily housing in a particular area. So when a builder's remedy is granted, again, the town, its planning board, its zoning boards lose all control over the zoning of the developer's property. And that's the key point that I really want to impart upon you. Instead, the zoning of the developer's property is administered by the court, usually through a court-appointed master, who only reports and answers to the court. Again, if the developer obtains a builder's remedy, a maximum of 20% of the units will be required to be affordable, meaning 1 out of every 5 units. So if you have a 100-unit project, that would mean that 20% or 20 of those units would be affordable unless a court permits a lesser percentage. And courts will sometimes do that, particularly if there is environmental remediation or certain improvements that need to be made on the property that would otherwise detract from the project's economic viability. So again, the builder's remedy is not now and was not a popular thing with the folks. So finally, in July of 1985, in response to Mount Laurel 2, the legislature finally acted, and they enacted the Fair Housing Act. The Fair Housing Act did several things. Number one, it codified the Mount Laurel Doctrine, which legislation typically does in the wake of a landmark ruling by the Supreme Court. It also established the Council on Affordable Housing that's known as COA. If I could just see a show of hands of people who have at least heard the term COA before. Anybody heard that term? Okay. COA actually COA is an administrative agency. It's an administrative agency that was set up under the Fair Housing Act statute. And the other thing that the Fair Housing Act did was it provided municipalities with a voluntary administrative process through which they could satisfy their Mount Laurel obligations in lieu of litigating exclusionary zoning lawsuits in the court. Now, as the sole agency in charge of administering the Fair Housing Act, COA was vested with primary responsibility of determining and assigning municipal housing obligations. And that's really the significance of COA. They're the ones who determine what each municipality's fair share is or was, and they're the ones who administered compliance with that number. So a municipality had a choice. They could put themselves under the auspices of COA, or they could leave themselves vulnerable to a builder's remedy lawsuit. Most municipalities put themselves under the auspices of COA because if they participated in the COA process, they could become immune from builder's remedy lawsuits. So if they elected to participate in COA's process, municipalities would adopt what they call a housing element and fair share plan. That's a plan that the municipalities would adopt and submit to COA. They would choose where they would satisfy their obligation. COA would provide the number of affordable housing units. I'm going to talk about that more in a moment. And if you filed your housing element and fair share plan with COA, you could petition COA for something called substantive certification of your housing element and fair share plan and your land use ordinance. Now, substantive certification is another very important term. Remember, I told you to think about the builder's remedy in terms of a sword. Think of substantive certification as a shield. That substantive certification was your protection as a municipality. If your housing element and fair share plan was granted substantive certification, then you were immune from builder's remedy lawsuits during the applicable period. Now, if COA determined, again, that a municipality's housing element and fair share plan was consistent with its rules and criteria and made achievement of that town's fair share obligation realistically possible, then COA was required to certify the plan. Now again, the municipality's obligation is to plan for, to provide a reasonable opportunity for affordable housing to be constructed. The town does not have an obligation to actually build the housing, nor does a town have an obligation to ensure that the housing is built. It simply has an obligation to provide a reasonable opportunity for the housing, and that usually occurs in the form of dialogue between property owners who want multifamily housing built on their property and the municipality, and that is what usually results in the planning of where affordable housing is planned for. Again, upon receipt of substantive certification from COA, a municipality's land uses ordinances were rendered presumptively valid in an exclusionary zoning litigation for a period of 10 years. Now, COA, what they did was they came up with this concept of rounds. So you had an obligation to provide X number of affordable housing units, say, in round one, which lasted 6 years, 1987 through 1993. And then there was round two from 1993 through 1999. And under the first round rules, COA determined that there was a statewide need of affordable housing of 147,707 units. The way this works and the way Parsippany or any municipality gets its number is that first there is a statewide need that's computed through a formula. And then that statewide need is distributed on a regional basis. And what the state does is they use the HUD regions, we're in Region 2, as the geographical areas where the need flows down from the statewide need. And then from the regional requirement flows the requirement for each municipality. So you can't look at Parsippany's number in a vacuum. It has to be looked at in the context of both the regional need and the state need. That's the way it works. And I think we talk about that in the last paragraph, last bullet point there. So under the second round rules, and again now the second round is between 1993 and 1999, COA reduced the total statewide affordable housing obligation to approximately 86,000 units, and that was largely due to the 1990 census, which indicated that there were considerably fewer substandard units. COA also permitted municipalities to reduce their fair share obligations with a variety of credits and adjustments. And these are still relevant concepts here today, tools, if you will, that municipalities have to reduce the impact of court-mandated affordable housing projects on them. For example, the state incentivizes municipalities to satisfy a portion of their obligation by utilizing rental units. And I think it's that up to 25% of your total obligation can be satisfied with rental units. And the incentive is in 2-for-1 credits. So for every 1 unit of rental housing that the municipality provides, you get 2 COA credits as an incentive to provide rental housing. The state puts a big premium on that. There are prior cycle round credits. So if you had excess credits in a prior round, you could utilize those excess credits as credits towards your next round obligation. There's also the concept of a vacant land adjustment, which is a concept that we believe ultimately will be very relevant in Parsippany. That concept is that, well, suppose you get a number that is just so big that you don't have enough vacant land in a municipality to satisfy that number. If you use the vacant land adjustment, there is a mechanism whereby you can actually reduce the actual number of units that would be required to be constructed in your municipality. So these are concepts that have been around for a long time. They are still concepts that are going to be relevant tools, if you will, that Parsippany will be utilizing in trying to comply with its third round obligation. So COA first proposed, again, you had The second round rules expired in 1999. Now, in 1999, that was a long time ago. I was a mayor back then, in 1999, in Rockaway Township, and Christy Whitman was our governor. And she knew that this was a very unpopular thing, this whole COA thing, and her administration did not promulgate third round rules. And then, of course, George W. Bush became the president. Governor Whitman resigned as governor and went to head up the EPA. We had an interim governor or two, and then Jim McGreevey was elected governor in 2001. Jim McGreevey was the mayor of Woodbridge. Woodbridge is a municipality that is really not all that dissimilar from Parsippany. It's a large suburban municipality. And Jim McGreevey knew, and I know because I know Jim McGreevey, that this whole COA thing was not popular in suburban New Jersey. And so when Jim McGreevey became governor, though, it became his responsibility to promulgate rules for the next round of COA. And so he came up with a new concept. He said, you know, this concept of the state of New Jersey dictating to municipalities how many units they have to plan for, which would result in a lot more, you know, units, since the affordables are only 20% of the projects. That's not very popular. So he came up with a concept called growth share. Under growth share, the concept is very simple. You owe as you grow as a municipality. If you don't want any development as a municipality, you're not going to owe any affordable housing units. But if you were to grow as a municipality, you would owe units based on the growth. So the concept was that if you, I think we give an example here, if you had a housing project approved, say, for 10 units, you would have to provide one affordable unit for every 10 market rate units that were constructed. The concept also flowed through to commercial development. For X number of square feet that were developed of commercial development, you would owe Y number of units. And these formulas were very, very complicated and very, very intricate. Suffice it to say that you know, the growth share, while it allowed a municipality to determine its own level of growth, which had appeal to, I think, a large number of folks, that concept was challenged in the courts by the Fair Share Housing Center, among other housing advocates. And on January 25th of 2007, the appellate division invalidated the growth share rules. And in response to that, COA adopted new third round rules in 2008. The 2008 rules really, you know, they were just sort of a different form of growth share. It was the same concept. And those rules were also challenged, and in October of 2010, those rules were deemed also to be invalid. And then you had a change of administrations. You had the Christie administration come in, and on September 26th of 2013, the Supreme Court affirmed the appellate division's invalidation of the 2008 rules and sustained its determination that growth share as a methodology is invalid, and ordered COA to adopt new regulations based upon the methodology utilized in the first and second rounds. And so this die was cast. What we're living with now and what we will be living with for some time, this die was really cast in a very definitive way back on September 26th of 2013. And for those of us who are practicing in this area, we have been, you know, not surprised, I don't think, by some of the other decisions that have come down from the court since then. So in 2014, COA proposed its third round iteration of the third round rules. And let me tell you, COA was really struggling with what to do, because the last thing they wanted to do was to go back to the methodology of the first and second round, where numbers were imposed on municipalities. But that's what the court ordered COA to do. And the folks on the COA board were so conflicted and so troubled that they could not get the votes to pass their own rules. So COA deadlocked 3-3 on the vote and failed to adopt their own rules. And that was in 2014. So the Fair Share Housing Center, who can see a hanging curveball as well as anybody, took a swing. And from their perspective, they hit it out of the park. So they filed a motion to enforce litigants' rights. And on March 10th of 2015, we had a landmark decision by the New Jersey State Supreme Court. They found that COA's administrative process had failed and that COA was a moribund agency. That's pretty tough language coming from the state Supreme Court, saying that the Council on Affordable Housing is a dying agency. The decision was landmark. I call it the Back to the Future decision because it, first of all, returned determination of municipal compliance with constitutional Mount Laurel obligations to the court. Remember, initially, that jurisdiction was within the courts. The courts demanded, and eventually the state created COA. COA was a state agency to affix and determine compliance with the court's order. And now here we are some 35 or 40 years later, whatever it is, and now jurisdiction for COA determination and compliance has gone from the state agency back to the courts. And so the courts now, we have 21 vicinage courts in the state of New Jersey. These vicinage courts are essentially being directed to act as administrative agencies to both determine numbers, obligations based on round 1 and round 2 methodology, and to approve affordable housing plans and to ensure compliance. It directed the courts to use a similar process that would have been available before COA. So again, we're now asking, superior courts to act as administrative agency. We had one COA for the whole state of New Jersey. Now, in essence, we have 21 COAs making decisions in 21 different areas. And it gets even more confusing than that, because you may recall that I indicated that the need is from the state need on a regional basis, then to a municipal basis. The region is based on the HUD regions. The courts are county courts. So the geography doesn't even match, which just makes the process even more challenging and cumbersome. The case also afforded municipalities some protection from builders' remedy actions while the municipalities' obligations for the third round were being determined, and I'm going to elaborate more on that in a moment. And the case also affirmatively permits developers to file builders' remedies actions if a town is determined to be non-compliant. Now, I have a few slides here, which I'm going to breeze through quickly, that discuss Parsippany's history in terms of Mount Laurel compliance. Suffice it to say that Parsippany has a very good history, a solid history, a history that I think this municipality can and should be proud of in terms of COA compliance that spans several administrations. It is something that each administration and council has taken seriously and has done the right thing by the residents. And as a result of that, we had some goodwill when we went into court in July of 2015. Because in July of 2015, again, this is a result of the March 2015 decision by the Supreme Court, we had to file a declaratory judgment action, and we filed that action, and we sought a few things. Number one, we sought judicial confirmation of our compliance with Mount Laurel obligations in the past. And we also filed a motion for temporary immunity from builder's remedy actions pending resolution of the case. The court granted our motion, and it granted our motion in large part because of the good work that had been done in Parsippany in the years prior to 2015. And since that time, the township has met every deadline in litigation imposed by the court. We have updated our housing element and fair share plan, though at some point it will have to be updated again. And we've acted in good faith with all of the interveners. Interveners are property owners / developers who they seek to intervene at the case so that they get a seat at the table and pitch their property as a property worthy of being included in Parsippany's housing element and fair share plan. And Parsippany, while Parsippany does have some latitude, some control in that process to determine which properties are in, which properties are out, that is also a function of, A, what is our ultimate number, and where can we plan for that number, and B, what is the suitability of the sites that are being pitched by the developers. A few facts about the case. There are about 300 towns in New Jersey that have filed similar declaratory judgment actions. And by the way, I should say that not all municipalities in the state of New Jersey are subject to the Mount Laurel case, at least as it relates to what we call the prospective need or new construction obligations. If you're in certain urban aid municipalities have no affordable housing requirement whatsoever. So Newark, for example, there is no affordable housing. This doesn't affect Newark at all. It doesn't affect Camden at all. It doesn't affect about 48 or so municipalities in the state of New Jersey. So when you take that number out, 300 is virtually every municipality in the state of New Jersey that is affected by this decision. So nearly every one of them, if not every one of them, filed the same action that we did here in Parsippany back in July of 2015. Now, approximately 100 towns or so have settled their cases with the Fair Share Housing Center and the developer interveners. Most of those settlements, quite frankly, have come in the, well, to us, Middlesex County or South Jersey, but have come in sort of Middlesex and South. Why has that happened? It's happened because the judges in that part of the state have really been the trailblazers. They've been, the judges that have most aggressively managed the cases, permitted cases to move forward towards trials. And so that has created an environment of enhanced awareness by local governments and by the citizenry because the cases are being litigated at a faster pace than they have been, say, in Morris County or Essex County here in the northern part of the state. Although there have been cases that have been settling in Morris County, and there are several cases that I think are clearly on a settlement track, there are other cases that are not on settlement tracks, but the process is still going to take some time to get through. Fair Share Housing Center, has been offering discounts on the obligations, and we're going to talk in a moment about what that means, because at its heart, this case is not a case so much about the law. It's a case about the battle of experts. What's our number? That's what every municipality wants to know. What's our obligation, and how can we plan for it? And that is not a question of law as much as a question of, who's the more credible expert in the eyes of the court. And so the stakeholders in the litigation have retained experts. The Fair Share Housing Center, which is the housing advocates, have retained Dr. David Kinsey. Dr. David Kinsey, as you see on the screen, is a PhD, well known in this area, former planning director at the New Jersey Department of Environmental Protection. And let me say that there are very few experts who are qualified or have the capability of serving as experts in this case. Because again, the first number to establish is a statewide number. So you need a lot of statewide data in order to be able to use a methodology to come up with a number that would be sustained by the court on a statewide basis. And then from there, you take the need and parlay it out on a regional basis and then a local basis. So it's not like Parsippany can just get, our local planner, who's a great planner, it's Nikes or somebody else like that, to be our expert in the case, because they don't have the statewide data. Maybe they do, but there's very few people that have the statewide data and the ability to provide the reports that need to be provided and to provide the testimony that would need to be provided to be persuasive upon a judge. Now, the municipalities retained initially Dr. Purcell, who was a professor at Rutgers. Unfortunately, shortly after he was retained, he became ill, and towns then engaged a consultant by the name of eConsult. And the municipalities had to organize. We had to organize on our own. This isn't being done through the League of Municipalities. This is being done by towns really at the professional level, lawyers and planners getting together, recognizing that we needed, not only from a credibility perspective, but from a cost perspective, to engage the same professionals. And so this consortium of municipalities across the state, of which Parsippany is one, has retained eConsult, as many other towns have done, all towns have done who are part of the consortium. And so this is what the court needs to address. What is our number for the third round? The third round being from 2015 to 2025. That's the third round. And again, that involves a complex process. The essential variables are the amount of vacant land, the income levels of people living in the municipalities, and the employment opportunities. And based upon the numbers you're going to see in a moment, congratulate you all, you're very wealthy people, even if you don't know it. The state says you are. You have a lot of vacant land, and you have a lot of employment opportunities close by, which means, as you'll see in a moment, Parsippany, at least in the eyes of Dr. Kinsey, has an extraordinarily significant affordable housing round 3 obligation. Now, remember before we talked about compliance mechanisms that are available to help mitigate the impacts of a large number on a town. Rental bonus credits, there's a thing called smart growth credits, redevelopment area bonus credits, vacant land adjustments, and the like. And these are all tools that Ed Nikes, our planner, who I apologize I forgot to introduce, who's here tonight, is and will continue to utilize in devising the ultimate plan that becomes Parsippany's housing element fair share plans. Now, there are also some caps that apply, mercy rules, if you will, to say that if a number gets too high, the obligation is capped. The first is a 20% cap, which really doesn't apply to Parsippany. Your obligation cannot exceed 20% of the total housing stock in town. There are some towns where that cap does apply. Parsippany is not one of them. The other is the 1,000-unit cap. The 1,000-unit cap is a very applicable cap to Parsippany, as you will see momentarily. But there's a question about what the cap applies to. Remember, I said that round 3 is from 2015 to 2025. Well, what about from 1999 to 2015? You'll see in a moment that that's a period that's referred to as a gap period. Does the 1,000-unit cap apply 1,000 units to the gap period and another 1,000 units to round 3, or does the 1,000-unit cap apply from 1999 through 2015? The courts have not adjudicated that issue, so we do not have any guidance. I can think of a lot of very good arguments why, under these circumstances, the 1,000-unit cap should apply through 2025, and I may have an opportunity to make those arguments at some point before the court. But that is an open issue. Now we get to the, as they say, the interesting stuff. These numbers are somewhat alarming. If you look at Dr. Kinsey's column, and again, Dr. Kinsey is an expert retained by the Fair Share Housing Center. And this is what Dr. Kinsey says Parsippany's obligation is. He's saying that for the gap period, and again, that gap period is between 1999 and 2015, that Parsippany has an affordable housing obligation of 1,229 units. He's also saying that there is a prospective need for the third round from 2015 to 2025 of 1,183 units. And so that's the number that Dr. Kinsey says Parsippany owes. That's just affordable housing units. That's 20% of the total number of units, according to Dr. Kinsey, that Parsippany must provide a reasonable opportunity to be constructed in town. We're going to do the math for you in a moment. eConsult, who is our consultant, has indicated that our prospective need is 0 and that our gap period obligation is 224 units. Now, for those of you who either attended or watched our March 22nd presentation, you're going to say, wait a minute, Inglesino, the numbers weren't quite that high in March. They're higher. They are. They're higher by 312 units, according to Dr. Kinsey. You say, well, how could that be? I'm going to talk more in a moment about a trial that is currently pending down in Mercer County. But as part of that trial, Judge Jacobson ordered the experts to prepare gap period studies in connection with that litigation. And the experts prepared those period studies for every municipality in the state. And so last week we learned that Dr. Kinsey has increased Parsippany's gap period obligation based upon the instructions that were given by the judge. So that is why your number, since March 22nd, according to Dr. Kinsey, has increased by another 312 units. Now, we do have some prior round components. We have 82 surplus credits. Wait a minute. That's cut off at the bottom of the page, I guess. Hit it again. There we go. We have 82 surplus credits from prior rounds. And, here are some of the projects that have already been completed, that are already in town, that show you the number of units, the number of credits. So the bottom line here for our purposes is we have 82 surplus credits. Remember, we can use surplus credits to offset our obligation in subsequent rounds. This is just a slide to show where those existing prior round projects are. Okay, and these projects all exist in town. None of them are proposed, but those are the projects from where you derived additional credits. Now we have third round plan components. We have our 82 prior credits. We also have additional credits that we've been able to obtain since the end of the second round. And you see some of those projects listed here. The alternative living housing, 13 locations, 97. Recognizing where the world was going back in 2010, we decided with the administration to engage in a policy of trying to help fund nonprofit group home type housing in Parsippany with money from our Affordable Housing Trust Fund. We did that not only because it was a humanitarian thing to do, but also because we knew we were going to be able to accumulate COA credits that we foresaw that would be helpful to us in satisfying third round obligation, which at that point was not apparent, but which we foresaw. Let me back up for a moment. We do have an Affordable Housing Trust Fund. That money is not funded by the taxpayers. That money is funded by developers of commercial development. So when somebody wants to come in and build a building like the UPS building that was approved a year and a half ago or so, that developer has to pay an amount of money to the town equal to 1.5% of the assessed value on that building. And that can be a pretty big number. Half of that money is usually due at the time of a building permit, and half of that money is due at the time of a CO. That money goes into a trust fund, and that trust fund can be used by Parsippany to fund worthy projects such as Habitat for Humanity, such as group home projects and the like, or could be used or leveraged by Parsippany to build an all-inclusive, 100% affordable housing projects. And there are some towns that are doing that. And, you know, from Parsippany's perspective, all options are on the table. I mean, if you go to East Hanover has the Nike site. Their goal over there is to build 100% affordable in one location. They have a site where they can do that. So each town and each situation is a little different, and certainly the concept of a 100% affordable housing project or two is something that is always up for consideration. That trust fund money can be used to do that, either as to do the project in all cash, or it can be used you know, in conjunction with bonding so that you can leverage that money to do that. That's not in our plan. I'm just giving you possibilities and options. I'm not advocating. Council hasn't decided to do any of this. I'm just trying to provide you with an array of options that the town has at its disposal to try and meet whatever the obligation is in a way that minimizes impacts on residents. So we have a total, according to Mr. Snikes, of 370 credits that we can apply towards our third round obligation, whatever it is. Okay, that's the point there. So, talk about our third round. Well, we have third round components of the plan. At the moment, we have two sites that are in the third round plan. One is a site referred to as the Stanberry site, which is the former Delta Dental, next to the Delta Dental facility on Route 10, sort of on the border of Hanover by 287 interchange on 10 East. You know, it's a vacant site, building's vacant. It's been bought by a group called Stanberry, and we are in the process now of negotiating a redevelopment plan in which the town will pick up a significant number of affordable housing units, and that's slated to be a mixed-use project. Again, that is in the process of being negotiated, but that's one site. The other site is off of Edwards Road, off of 280. That's owned by Parsippany Partners, who've owned the property, I think, since the 60s or something. They wanted to do some multifamily housing. The aspect of that plan there that was attractive to the council was that there also was an opportunity to do some flood mitigation in that area. That is an area that does flood. Edwards Road does flood. And as part of that project, there would be flood mitigation put into play as well, which would prevent future flooding. That project is in the process of getting DEP permits so that we know that it's viable. So those are the two projects at the moment that are in our plan. So, in Parsippany's best case scenario, there's a 224 unit obligation, according to our consultant, eConsult. And again, since we have 370 credits that we can apply towards that obligation, under the best case scenario, Parsippany would have a net zero obligation. In the worst case scenario, Parsippany would have an obligation, according to Dr. Kinsey, of 2,412 units. Now let's do some math so you can understand the magnitude of the potential impact and the magnitude of the challenge that the administration, the council, and your professionals face in terms of representing your interests. In a worst case scenario, at 2,412 units, this is a potential, this is a worst case scenario. You could have a total of 12,060 new units in the aggregate. Why is that? Because, again, this is 20% of what the total obligation would be. So you multiply 2412 times 5, and you get 12,060 units. I don't foresee that being the case, even if 1224 was our number, because we have tools in our toolbox to help mitigate that. We have some additional credits of 370 that we can apply, et cetera, really using these numbers for illustrative purposes. But it does give you a sense of the fact that the impacts in Parsippany could be rather significant. If the 1,000-unit cap applies, then, there's a scenario there. 20%, 1,000 units times 5, that's still 5,000, potentially 5,000 new total units in town. That's a lot of units. I want to update you at this point in terms of what's been happening in other parts of the state, because a question that you may have is, well, wait a minute, how could there be such a divergence between eConsult and Dr. Kinsey? And what can I share with you in terms of which expert is likely to be regarded more credible by the courts? And all I can do at this point is to share with you what has happened in other courts in the state. The seminal trial, and the first trial, was held in Middlesex County. And that trial was decided on July 21st of 2016. And the trial did not go well from the perspective of municipalities around the state. The court concluded a few things. Number one, the court rejected eConsult's methodology. And this, by the way, is a 104-page decision written by Judge Wilson. I'm going to talk a little bit more about him in a moment. 104-page decision. This was a very lengthy opinion in which he made a lot of factual findings. He rejected eConsult's methodology and found that it deviated from COA's prior round rules on 26 occasions. He accepted Dr. Kinsey's methodology and found that it was consistent with the prior rules. He assigned South Brunswick a round 3 prospective need obligation, again 2015 to 2025 is the round 3 period, of 1,533 units. He stripped South Brunswick of their immunity and has permitted builders' remedy lawsuits to go forward. And those, there are several, I think there are 7 builders' remedies lawsuits that are pending in South Brunswick. He also ruled that there is a gap period obligation because municipalities had, this became an issue of contention, where municipalities argued that there should be no obligation arising between 1999 and 2015. Of course, the housing advocates argued that there should be a gap period obligation. Judge Wilson found that there is a gap period obligation. The appellate division sided with the municipalities. But in January of this year, the Supreme Court reversed the appellate division and found that there is a gap period obligation. And so as part of the Mercer County trial, Judge Jacobson, which is pending now, Judge Jacobson ordered that the experts go back and compute what the gap period obligation is. Again, that's why Parsippany's numbers have increased since the March 22nd program that we put on. Dr. Kinsey increased it by 372 units and eConsult by 224 units because eConsult said we had no gap period obligations. That's why the numbers are a little different. Now, there's been some news and some developments as it relates to Judge Wilson's decision. Judge Wilson is a judge who was largely, I think it's fair to say, was viewed as a pro-developer judge. Judge Wilson left the bench shortly after his decision and went to go work for a large developer, a well-known developer in the state of New Jersey, and actually appeared in court on a Mount Laurel case, contending, I think, that he was there as the client and not the lawyer. That drew the ire of some lawyers who are representing South Brunswick who have filed, motions now trying to vacate Judge Wilson's decision on the basis that he was biased, et cetera, and we'll see how all of that plays out. Of course, I'm sure Judge Wilson would say that he did not act in a biased way, and he would probably point to his decision as being upheld by the Supreme Court as evidence that his decision was the right decision, from a judicial standpoint. Because remember, Judge Wilson's decision with regard to the gap period was initially overturned by the appellate division, but in January of this year, the Supreme Court overturned the appellate division and found in favor of Judge Wilson. Though I did want to alert you that there's a lot of noise surrounding the decision by Judge Wilson. Now, there is also a decision that is pending in Mercer County before Judge Jacobson. And there's a tremendous amount of time, effort, and money being put into this trial. The trial is bifurcated into two parts. The first part is, the expert part, what's your number? The second part of the trial is, what is the gap period obligation? The first part of the trial is going to be finishing up, I think, in the next week or two. And then, the judge will either take a break or go right into the second part of the trial. I'm not sure which. And we don't know whether or not the judge is going to issue one decision at the end of both parts of the trial, or whether she's going to issue a decision, on the expert number part first, and then another decision on the gap period. We don't know. We would expect that at some point over the summer, we will have a decision from Judge Jacobson. I will tell you this as well, that I believe it was Judge Trancone in Ocean County who commissioned a planner, Richard Redding, to come up with numbers from the judiciary's perspective. Because I think that what's happening is that neither Dr. Kinsey nor eConsult have 100% credibility because they're representing their respective clients and their interests. And so Mr. Redding was commissioned by the court to prepare a set of numbers, I guess supposedly from the perspective of the court. And judges are not equipped to do this work themselves. They need an expert for them as well. And so Redding's numbers are either just out or about to come out. When we have them, we will share them if we have another one of these presentations, because there is a growing sense at the moment, and this evolves every day, so perspectives can change, but at the moment, there is a perspective that Redding's numbers are likely going to be somewhere between Kinsey's numbers and eConsult's numbers, but probably skewed more towards Kinsey's numbers, and those could be the numbers that I think other judges gravitate to. Because if we were to have 21 different trials, which we could have, we wouldn't have this resolved until the fourth round numbers are due in 2025. Because Fair Share Housing Center is intimately involved in each of these trials, they can only participate in one trial at a time. And, so the question is, which county is next? And I suspect it's not going to be Morris. But as trials are conducted and findings are made by judges, and those findings are exposed to the appellate process and ultimately ruled upon by the appellate division and or the Supreme Court, I think the picture is going to become increasingly clear as to which set of numbers, govern. And, once that occurs, municipalities are really going to have no choice other than to figure out ways to comply. Because if you don't, then you're subject to the builder's remedy lawsuit. And when that happens, the municipality essentially loses all control to manage the process, not only in terms of where the projects will be, but also to engage in the localized give and take between planning boards and developers in terms of how those projects, the impacts of those projects can be mitigated. So what do we need to do now? our primary goal is to maintain our immunity. We have that immunity. By court order, we must meet and negotiate with interveners in order to maintain our immunity. Mount Arlington lost its immunity. So it's not as though a judge won't hesitate to pull your immunity if you're not acting in accordance with the order. So if you, in those meetings with developers, I'll tell you right now, they're not in public. Those are necessarily meetings that occur at the professional level. They are closed meetings. There is a litigation, and the discussion any discussion that I may have with the governing body regarding prospective projects will be held in closed session. So, if somebody says we want transparency, we want all of this out in the open, not at this stage of the game. It will not be, and I want everybody to know that, and it can't be by law. I wouldn't be doing my job. We don't telegraph to our adversary what we're going to do. And once we speak in a public forum, in a public domain, that's exactly what we're going to do, and we can't be there. So there will be a period of time. So if somebody is staked outside my office and they see a developer who's suing the town in the Mount Laurel action walk in my office, you read about it on a local publication, but it doesn't mean we've done anything wrong. We're doing what we're supposed to be doing, which is meeting and discussing. Before any decisions are made, there will be a full public presentation so that the public understands exactly what the plan is, what the rationale for the plan is, that there will be public input, there will be public discussion by the governing body, and there will be a public vote. When that will occur, I cannot predict. It's not going to happen next week or next month. This is still part of the process. From my perspective, I do want to see what Judge Jacobson rules. I want to read her opinion. There will be a lot of discussion about that within the legal and planning community. There may be appeals. I think, I suspect that while that process is going on, that courts are not going to put a tremendous amount of pressure on municipalities to do much of anything because, what's the court going to do at that point? We're waiting to see, I think, sort of what the consensus becomes in terms of which experts' numbers are accepted. I could foresee, although I don't know this, let's say, for example, that Judge Jacobson adopts Mr. Redding's numbers. You could see a situation where the judges largely decide to do that. The judges do speak. They do meet collectively, the Mount Laurel judges, and each vicinage has a judge or two who are designated Mount Laurel judges. So they are conversing about these issues. They understand the impracticalities in terms of time, expense, etc., of having 21 trials in 21 different vicinages. And I can tell you that I think there's an effort to avoid that if at all possible. So, that's the best I can tell you right now in terms of my crystal ball, which may be accurate or may not be. We'll just have to see as time goes by. So again, we're going to continue to meet with interveners, although I have to tell you there hasn't been a lot of that. It's up to the interveners to come up with plans and to share them with us. Those plans, by the way, we're getting in all kinds of Oprah requests for plans. We're happy to get the Oprah requests, but we're not going to share any information that's subject to the litigation as part of those requests. But again, before any decisions are made, there will be a full and thorough presentation made to the public. There will be the opportunity for public input, questions, etc. And then, of course, there will be discussion by the governing body before any votes are taken, and I don't envision that to happen in the immediate future. If you have, and I'm happy to take whatever questions that you have this evening, but if there are questions that you have in the aftermath of tonight when you go home and you ruminate over this stimulating presentation, my email address is right there. A bunch of folks emailed me from the last time we did this. I think I got back to everybody. someone had a question about whether or not what impact affordable housing project would have on residences in the surrounding area. And I told that resident that I'm aware of a study that was done on that very subject, and I'm still attempting to get that study. So if that's a question that you have, I'm trying to get the study. I don't know, I can't speak to the study, but I know there's a study out there because I heard it referenced in testimony before a planning board on an application. But I will get back to you as soon as I can with whatever questions that you have. So in any case, that concludes my presentation. There's a microphone up here. So if anyone has a question, please come on up to the microphone, state your name and address, and fire away. Sure, come on up.
Thank you for your excellent presentation. Thank you for coming tonight. My name is Sid Khan, 85 Stockton Court, Morris Plains. And the question is, in having conversations with quite a few of my friends, they seem to be concerned, will something happen to their tax rate in town? Will there be an increase in taxes because of new development?
Good question. You know, it's hard to say. What I can tell you is that the impact on taxes is unfortunately not a consideration that the town will be able to. I mean, our obligation is our obligation. We're going to have to figure out a way to satisfy that. Again, I know that the council and the mayor want to satisfy whatever the obligation in a way that absolutely minimizes the impact on the folks here in town. And one of the most significant impacts, of course, is taxes. There's a lot of development in Parsippany. You are fortunate right now to have, I think it's the third lowest tax rate in Morris County in terms of a municipal tax rate. Of course, there's a lot of other things that make up your property tax bill. I do know that by the way, the municipal component of your property tax bill is only about 22%, 22.1%. So, you know, you get a tax bill in the mail, it's 22.1 cents of every dollar goes to fund your local government. The rest goes to the schools, the county, the open space, the fire districts, et cetera. But, you know, what's the impact of development? Yes, it will increase revenues. What will the increase in expenses be relative to services, relative to costs? Can't answer that. I don't know that we're going to be able to answer that for a while. But fiscal will be a consideration in terms of, you know, I think how the obligation is met, but the obligation is there irrespective of what the impact is going to be. Yes, sir.
Yes, Dennis Ferlenzo, 25 Monette, Morris Plains.
I'll try to repeat the questions so that folks in the back can hear.
I think I'm going to rehash what he had questioned you in regards to, is there going to be an impact study in regards to any development? And what I mean by that is the burden may be on schools, the police, and the old infrastructure that the town supplies to the residents. So that was, you know, prior to getting there, I know that's getting a little beyond that, but when it becomes a fruition, if it does, is that looked at? And,
yes.
And is that something that you go into when you do go to court and you say we're going to have to increase our school system X amount, or we're going to have to hire X amount of teachers, or we're going to have to hire X amount of policemen? I don't know if that's part of the criteria you have to take to the judge when time, you know, comes.
Good question. The question is on impacts and whether or not and how the municipality will assess impacts, and specifically whether or not school children is a basis that could affect municipal decision making. What I can tell you generally is it's unlawful to base a zoning decision on the number of school children that will be generated from a particular project. It's unlawful. It's called fiscal zoning, and it's unlawful. So I know that politically, folks, it can become not in vogue. I mean, I learned when I was a mayor, in order to get elected, you had to be against children. That was hard as a father of two daughters at the time, living in a family community. But I also understand the realities of what's happened, and that goes back to what I talked about at the beginning of the presentation. As suburban New Jersey has matured and grown, it's gotten to a point where I think many folks feel that it's been overdeveloped. We feel the effects of traffic.
Right.
We feel the effects of taxes going up, and we attribute those taxes going up to development, to increased services, increased need for police, increased need for fire, increased need for schools and teachers. And believe me, we are very much aware of all of that. Our planners are very much aware of all of that. And the way in which Parsippany satisfies its ultimate obligation will be done in a way that will minimize impacts. But our obligation is our obligation, and we have to meet that obligation irrespective of whether there are impacts on traffic, on schools, on the need for municipal services, because it goes to reason that, the result of the Mount Laurel doctrine is more development and more people. And with more development and more people, you tend to have an accentuation of those things. What we have to do is to manage them in a way that minimizes impacts. We have to be very smart about the way that happens. And rest assured that we are going to be very focused on those issues so that the growth is managed in a way that will have the least amount of impact on the township.
Now, are those numbers in your presentation to the court? Would you know foresight if they say X amount of units? Do you have, the crystal ball to say, yeah, we're going to have to increase our...
The courts don't care.
They don't care.
The courts don't care. Unfortunately, that's, the impacts on the municipalities.
But, you're going to have to knock school. Either add schools or add to schools. That schools seems to, that's probably...
Schools are a tough thing. I can tell you, for whatever it's worth, that statewide in the state of New Jersey, enrollments are going down.
All right.
I can tell you that statewide in New Jersey, enrollments are going down pretty significantly, and it's population. We're at a point in time in the population growth, which the planners will tell you, where the baby boomers are, beyond the age of where they're having young families and children. I'm the last, I think, year of the baby boomer generation, so we're beyond that. Behind us is the Generation Xers, and there are many fewer Generation Xers in society, and behind them, of course, are the millennials, and they're a very large group, but they're several years from coming in. So what you're seeing demographically in the state of New Jersey is that school populations are decreasing. That's just a fact. Does that mean that there isn't going to be any impact on schools as a result of the Mount Laurel litigation? No, that's not my point. My point is that, though, that is not going to be a defense to having to comply with the Mount Laurel doctrine. Okay. Our number is going to be our number, and we're going to have to figure out how to comply in a way that minimizes the impact. The court is not going to consider our number based upon how many school children it's going to generate or how many cars in town it's going to generate. Those are not considerations.
So it could affect your tax rate?
Well, it's possible.
In a quick statement, that it can increase your taxes.
It can. There's no question.
Really blow it out, because not as like a very large increase.
It's hard to say. And again, it's not like you're going to wake up, one day and all of a sudden.
Once this properties or whatever in place, you're going to have to face the music somewhere. Someone's going to have to pay for it. If the state isn't going to compensate, or the monies aren't going to be compensated for that particular reason, it's got to come from somewhere.
Believe me, we know it's a big challenge for us. I think Mr. Snikes, our planner, has something to add on that topic.
Okay. Thank you. Something I wanted to focus on, too, is we did talk about the total numbers that we would potentially have to address. recognize that in our mechanisms that we're looking at, or the toolbox that we have at our disposal, is we're looking at vacant land. And what is the capacity for us to build certain properties or reach certain densities in the community? And that's something we're looking at very closely. So what I wanted to stress, and I know it was mentioned at the beginning of the presentation, is that we are looking closely at that vacant land issue to see, in fact, what is called a realistic development potential is achieved. So I know we're mentioning these large numbers, but we're also looking at trying to use the other mechanisms to reduce the number to a more approachable number that we can try to address.
Now, will those projects, the Green Acres, I don't know how much Green Acres land we have in Parsippany.
You can't touch Green Acres.
You can't touch it, so
No.
that would be off the.
No, they're
so
protected.
it's only existing, or zoned areas, either commercial or
Correct.
residential.
But they also look at properties that have a potential for redevelopment. So that is something that we're also looking
Now,
at.
what breaks that criteria? How does
It's
that?
very difficult. It's a very complicated process.
All
But
right.
they look at certain properties that may have an older infrastructure, older conditions. Maybe it's outdated in
All
design
right,
and
but it's
characteristics.
an existing building, and then they'll just knock it down and
But then again, we may be able to convince the courts and the court master as we negotiate this is what sites make sense. Are they close to mass transit? Are they close to highways? Things like that, and infrastructure that's available. So that is certain other.
And that's where, antiquated office buildings provide an
Right, I
additional
mean, you
challenge,
mentioned that
because
before.
those are typically close to highways and things of that nature. In terms of vacant land, and there was a lot of discussion about the Waterview site years ago, we settled there and are in the process of acquiring 10 acres of that site to ensure that site will not have housing. We settled with the developer, and then Fair Share Housing filed a lawsuit challenging our settlement. And so that put a very big dark cloud over our ability to preserve, that 10 acres of the Waterview site. Just about a week or so ago, that litigation was settled between the developer and Fair Share Housing, which has now paved the way for Parsippany to acquire that property. And when we acquire that property with open space money, we will be able to assure the folks there that property will be forever protected from any residential development. And so I know that's something that we're all very proud of having been able to accomplish, because at the time, and again, you look back now at these decisions, really going back to September of 2010, which is why, at the time that the Waterview site was being heavily discussed, we were concerned about the future of that site and its ability to provide significant amount of affordable housing, because we knew that it met a lot of the suitability, or all the suitability criteria. And so obtaining that property as part of the settlement with open space funds is really a big deal, because it takes that property off the table.
Very good.
And Fair Share Housing has settled that case with the developer, which is key. So now we are able to go forward and buy that property and save it. And I have to tell you, I think that's an enormous accomplishment for the township.
And that would also landmark sites that were maybe,
Well, any sites that were acquired with open space money would be sites that would not be able to be developed.
historic sites.
Yeah.
and all that. Okay, thank you.
Okay, thank you very much for your questions. Yes, sir.
Yes, Andrew Springer, 101 North Beverwyck, Lake Hiawatha. What I read in another town's transcripts, I believe it was Montclair's, they actually discussed the two levels of affordable housing, and I noticed you didn't go into those tonight. The moderate income housing, at which they set aside 50% of their income, and a lower level of about 30% of the income, I think I read. What you can't back form is usually where those how much earnings those people actually have. So I was wondering if you had that information on you tonight. And, well, let's go to that one, and I'm trying to
Yeah,
rethink my
so
last question.
what I was giving you was the aggregate number. You know, this stuff is, there's a lot of it, and it's complex. So I would say that, you know, you're in the AP course of affordable housing. But there's advanced AP courses, which you're referring to. So of that 20% set aside for low and moderate income housing, notice I always said low and moderate income housing. There are different categories of low and moderate. There's moderate, low, moderate that have to be complied with within that 20%. Mr. Snikes is going to be able to elaborate a little bit on the actual income levels that comport with each of the different categories. But there's a thing called UHAC, Uniform Housing Affordability Controls, that have to be complied with, that regulate the topics that you're talking about. They also regulate the number of bedrooms. So within the 20% set aside, 20% of the units have to be 3-bedroom units. That's a requirement of the COA rules. And the COA rules, at least in this regard, are still being utilized by the courts. Do you have some of the income numbers?
Yes, I actually don't have that spreadsheet in front of me, but I can cite certain numbers. For a household of one person for a moderate income, it's approximately about $40,000 a year that they can make, whereas a low-income person is more around $30,000, $31,000, thereabouts. There's also a very low category, too. But what you may have noticed in the calculations, some of the credits that we've been able to establish, is that your assisted living, or excuse me, your group home facilities do comply or provide a very low income level of affordable units. And that does help satisfy that amount of your need as well. So I just wanted to identify that as well. I know you mentioned 2 levels, but there's actually 3 levels. Very low, low, and moderate income.
Okay, I can flip the mic till I can figure out my second question.
Certainly.
And let me just, one other follow-up answer to that question, which is a logical question, is also that there is not preferential treatment given to residents in the municipality. It's done through a lottery system, and folks within the region are eligible, and there would be a third party that would administrate, you know, who gets the units. It's done by lottery. And while there are minimum notice requirements that have to be provided, one way in which we can, you know, try and I'll watch my words since I know we're on camera, one way in which we can try to help increase the odds for Parsippany folks to be able to avail themselves of this housing is by just, you know, getting more notice out than is required. And then you would presumably have more folks from Parsippany putting in for it, which would increase the odds that Parsippany residents would be able to avail themselves of this housing. But it's done on a lottery system, and people within the region are eligible, and we can't give preferences to the host community.
Okay, I did remember my second question. I was thinking if a project happens to go up and it's been built and it doesn't end up cost positive for the township, and there are the lower level incomes, somewhere filling back on that, we pay for that in taxes, whether it's a state tax or local taxes, right? So on a big level, if a lot of low income housing, or low, come in, our taxes would probably go up, correct?
It's possible. I can't say. There's so many different variables and dynamics as to that. What I can tell you is it doesn't matter from the vantage point that you have to comply. Sir?
Mitchell Lauren, 117 Edgefield Drive in the Morris Plains. I have a question on slide number 27, please.
Okay, these are third round components.
They're actually on the map. So are these actually approved projects on
No, there's actually, there's some existing mixed in with the, so the only proposed projects, Ed, why don't you point to them? There are 2 that I had referenced before, the Stanberry project
Right.
and the Parsippany Partners project.
Right, just for reference, this is Route 10 approximately right here on the map. This is the Stanberry development next to Hanover. That's at that location. And then the other proposed area is the Parsippany Partners located on Edwards Road. on the right-hand side of the map. What this map also shows, certainly, the first area is along Route 10, next to the township boundary with Hanover.
That's the vacant parcel next to Delta Dental.
That's Stanbury. And the other tract is Parsippany Partners, located on Edwards Road, between Edwards Road and Route 280 in that area.
And those are the only two projects that are currently in our housing element and fair share plan, which the court required us to submit a housing element and fair share plan as part of this process some time ago, and we did. I think it was April of 2016 that we submitted that plan or thereabouts.
A specific question, though, regarding, I think it's called CBH, on which is the lower left.
Okay.
Is that currently built, being proposed? What stage of development is that in?
In this area here?
Yes.
Yeah, the reason why we identified the entirety of the lot,
Uh-huh.
if you recall, some of those properties are the Morris County properties, or close to the Greystone area.
So that's why was my question.
Right.
That's where
And-
Greystone was, correct?
Right, the nursing facilities, many of the nursing homes,
Right.
the homes for the nurses, excuse me, that
Right.
were there, were actually converted. And we contributed funds to help convert those units into group home facilities.
Oh, so those were former the medical staff of Greystone. I see.
Exactly.
So that's already existing.
Exactly.
Yes,
Those homes were existing and they were adaptively reused.
Okay, excellent. So what about any proposed development on the old Greystone lot? Is there anything, have any developers come before you to request developing that, or is that owned by Morris County? Who owns that?
Well, the Greystone property is owned by the state.
Mm-hmm.
There was some property, and a large piece of it, I think, that was conveyed to the county
Right.
with restrictions. And so it's not property that is eligible for housing, and so I would lump that into the category of open space property for purposes of a Mount Laurel discussion.
Okay, but it's not quite Green Acres.
Well, but it's not, but for purposes of this discussion, you could lump it into that category of properties that would not be susceptible to development under Mount Laurel.
Okay.
It's property that would be exempt from development.
Okay, great. Okay, thank you.
And that would contribute towards our vacant land adjustment.
Yes.
Hi.
Yes, ma'am.
Anita Gervasio, 39 Intervale Road. I see that Parsippany has a lot of apartments, and I wondered if there is any impact in any way with any of this changes, any of these changes that we have to go through by the fact that we have so much apartment development already. Does any of that count, or is it part of any of the decisions that are made with any of these decisions?
Well, we do, with regard to apartments that were developed in connection with prior round compliance, over and above what was required, then we can count those units as surplus credits towards this obligation. And I attempted to describe that in the presentation. But a lot of the apartments in Parsippany, the garden apartments that were constructed, say, in the 1960s or so, those are not apartments that we can utilize unless, and this is another tool that we have in the toolbox, unless we attempt to purchase deed restrictions from the owners of those apartment buildings. So, but we would need a willing, party on the other side of the table to do that. So the way that would work is, again, we have money in our Affordable Housing Trust Fund. We have about $2 million, a little over $2 million in the Affordable Housing Trust Fund, which again was provided by developers, not through the taxpayers. In fact, some of the fees in connection with this, planning and legal, are paid for out of that fund. We could use some of that money to purchase deed restrictions from owners of apartments. So the owner would get a check. They would have to agree to deed restrict the unit to become a low and moderate income unit, and we could use that to count towards our obligation. Now, we would have to be able to make an economic deal with the property owner in order for that to work. And that is certainly, something that we have looked at and that we have attempted to engage in discussions with some of the apartment owners in town to try and do that. It's harder when supply and demand is allowing these apartment owners to get $1,800, $2,000 or more a month, because if they buy the deed restriction, the good news for them is they get cash. The bad news for them is the unit is deed restricted and they're limited as to how much rent they can get. And so in a market where people are willing to pay in excess of $2,000 a month and they're lined up at the door, it's harder to make that deal with the apartment owner. But it is it is something that we have attempted to do, and we'll continue to do so.
Do you have any leeway with taxes when you deal with a landlord of an apartment dwelling? I mean, is that one of the options that you have, is to maybe make some concessions in taxes that landlord would pay, or is that just nothing that is ever considered?
Unfortunately, we can't do that. The New Jersey's pretty strict. The taxes are set based upon the rate and the assessed value, and we don't have room to offer. We don't have the legal authority to offer a tax break as well. We can only offer money through the Affordable Housing Trust Fund in exchange for the deed restriction. Again, it's a tough market to do that because apartment owners have a lot of people lined up willing to pay them a lot of money. So we're doing what we can in that regard, but it's not an easy negotiation given the market circumstances that exist. Okay, thank you.
Hello, my name is Eileen White. I live at 26 Winding Way. Just for clarification, when you refer to the former Delta Dental site, would I get there by going Littleton Road, 10 East, and it's over there prior to the Marriott?
Yes.
That's it. Good. Thank you very much.
Prior to the jug handle.
Prior to Dryden Way. Okay. Thank you very much.
Thank you.
It is the Dialogic building.
The Dialogic building, that's the building.
My name is Bob Venezia. I live at 102 Brooklawn Drive, and I'd like to know how often the renters of existing affordable housing units are checked to make sure that they still meet their eligibility criteria. Who does the checking? Does the amount that the renters pay for affordable housing increase as their income increases? And what happens if they earn too much money and lose their eligibility?
Well, the compliance part of it is assigned to a third party, and there are companies that specialized in administrating, affordable housing compliance. And at the municipal level, I can tell you that my knowledge is really more focused in terms of what we need to do to comply with the requirements of who lives there, how many units we need to have, et cetera, how many of what type. The third-party administrator would be responsible for compliance going forward. I don't pretend to be an expert in that area. Ed, maybe you know a little bit more about that.
Now the microphone picks me up. Thank you. With regard to monitoring, there is a need for a yearly monitoring. When COA was in effect, we had to report to COA yearly as to each one of the units, who was monitoring the units, who was actually reporting as to the checking of the rents, checking of the income levels of the individuals that live at the facilities. Going forward, it will be the courts. What we've seen in some settlement agreements is that we have a 3-year period by which we would then have to report to the courts as to who's monitoring the units, how the units are being administered, and things of that nature, and whether or not they're still valid units.
But there
there will be checks on that.
And there are companies that have a lot of experience in this and have been recognized by the state for many, many years to do it, and those are the companies that would handle that and make the reporting to the town and to the court or whoever is going to monitor compliance.
But if they made too much money, if they were no longer eligible, they'd have to pay the full freight or get evicted?
No, presumably, the deal is that you have to, you have to satisfy the requirements in order to live in the unit, because the unit's deed restricted.
Yeah, they would have to leave the unit.
They'd have to leave. So
Okay.
if they made too much money, they would
Okay.
have to leave the unit.
Okay, and how many affordable units are currently under construction at the Modera apartment site on IMS Drive and the Water's Edge site on Intervale Road? And how many more affordable units are either under construction or proposed at other sites in town?
Well, the IMS site, as you know, because we've had some discussion about this at the council, was not zoned, was not authorized or approved by the governing body. That site was approved by the Board of Adjustment through a use variance. Unfortunately, there was not an affordable housing requirement imposed upon the developer on that site. I've made my opinion known about that. I think that was a mistake.
I agree.
We understood that at the time, but, again, that was not the mayor and council, it was not the planning board, so we have to live with that and move forward. Clearly, that would have presented an opportunity to get units, but, that's the way it goes. So, in terms of Modera's in Morristown.
Well, we have a Modera. There's a Modera in Morristown, and we have the
Maybe the IMS,
Modera.
I'm confusing with Modera. I mean,
What location is
It's
that?
on IMS Drive.
I think it's the same.
Oh, that would be the same
project.
site that we
Same
just
project.
talked about, yes.
Yeah, it's the same project.
Yes.
I know Modera because I represent Morristown.
Yeah, there is a Modera.
There's a Modera in Morristown,
Yes,
it's the
there
same
is.
developer. Mill Creek, yes, that's the name of the developer. Well, if you can, sir, let Mr. Venezia finish, and then if you'd come up to the mic, that would be great. Thank you.
Well, that's the end of my questions. I just have one observation, that we currently have 22,000 housing units in Parsippany. If we get a $12,000 unit increase in housing units, that's more than 50%. I mean, what kind of, how can you have, I can't have respect for, are the judges making these decisions in a vacuum?
Look, we live, and I didn't do this the last time, Mr. Venezia, but you caught me on a night where I'm going to do it anyway. The policy, this is what happens when elected officials don't set policy for the state. This is what happens when you leave it to the courts. And when you look at New Jersey, and again, this is why I went through the history of Mount Laurel, why I went through the history of zoning, why I went through the history of what New Jersey looked like back in the 1970s, so that you had a perspective of how this type of ruling came to be. But, the world is a lot different now than it was back in 1972 or 3 when the initial lawsuit was filed in Mount Laurel. Today, our urban areas are experiencing a renaissance. Today, our suburban municipalities and areas are no longer growing. They're regarded by many as being overdeveloped and mature. And when you look at policy, whether it be federal policy, and I know that the number one priority of our congressional delegation, both Republicans and Democrats, is to focus money into the urban areas. When you look at the grants that are given by the state of New Jersey, they are targeted into the urban areas. When you look at transportation funding, they are targeted in the urban areas. When you look at education funding, and you all know about the Abbott v. Burke decision that occurred back in 1997, allocating a lot of money in the urban areas, all the grants, all the incentives are all about growing the urban areas, which makes sense from a planning perspective because they're close to transportation hubs. They are underutilized. I mean, Newark is still less than half the population that it was in the 1960s. there's a lot of room to grow. So one would say, why don't we try to encourage development of affordable housing of the type that the court is imposing upon us in suburban New Jersey? Why wouldn't they seek to do that in more of urban New Jersey, where all of the state resources are being expended to encourage growth? And the reason is because our elected officials in Trenton have done nothing on this subject for decades, because it's been, a politically difficult subject for them to do anything about. And so what's happened is we have a court system that is stuck in an early 1970s paradigm, and they just keep going along the same path without recognizing the profound changes that have occurred in New Jersey. And so it's frustrating. It's frustrating for folks here, it's frustrating for us as professionals, and I know it's frustrating for the elected officials who, are stuck in a position where they have to manage this stuff. And, it's easy for people to go out and say, well, I don't support this and I don't support that. One of the reasons why the mayor was adamant about, having these forums where we were communicating with you was to provide you with the facts, the information, the court decisions, so that you understand, what it is we're dealing with. And the challenges that we have, to manage these decisions in a way that, again, minimize the impacts on the community. And that's what we're trying to do. So, sorry for that little divergence from my legal hat, but I couldn't resist.
Teresa Vieira, 71 Brooklawn Drive. I just have a few questions. One of them, from a regional standpoint, and I don't know if this would help us or not, but Morris Plains has a low-cost housing building on Route 53, and Denville just announced they're going to put a low-cost housing in the block next to the food town on Route 53. Now, will that help us in any way, the concentration of two low-cost housing units right on our borders? The other thing is, again, from a regional standpoint, have you looked into Morristown's needs and what they have and what they're doing?
Yes.
You have?
I represent Morristown.
Okay, well then you know more than I do.
I'm very
about it.
familiar with Morristown's situation on affordable housing. I'm their lawyer for this, for affordable housing and redevelopment and planning. So I'm very familiar with Morristown.
Are they being forced to put in or build more units? Morristown, I'm going to say.
Morristown has an obligation. And
they haven't met it yet?
Well, there's a third round obligation, and we are sort of, I think, at the end of settlement discussions with the Fair Share Housing Council. Mm-hmm. And I would suspect that within the next 2 weeks, there will be a settlement agreement presented to the Morristown Council, which will, serve to settle their litigation. Mm-hmm. But Morristown is a different situation than Parsippany.
Oh, I'm fully familiar with it.
And so we're, that's Morristown's situation.
Now, I have one other question. In the figures that you used on what Parsippany has to come up with, have you considered the units in Parsippany now that are rent subsidized? Well, the houses and the apartments?
Yeah, so the rent subsidies, if you're referring to like Section 8 housing, does not qualify, because a Section 8 housing is a voucher that goes to the tenant. Affordable housing, in order to qualify as an affordable housing unit under the COA regulations, it's the unit itself that has to be deed restricted. And so, it's
qualifies, not the unit.
Well, the unit has to be deed restricted, and then the family moving in has to qualify, under the criteria in order to
so
live
none
there.
of those figures help us out in reducing the amount?
The Section 8 housing, doesn't help so much. We don't have a housing authority here in Parsippany, so we don't have the ability to utilize a housing authority the way Morristown does. And to address your first question, unfortunately, the units in Denville will only help Denville.
Well, you have Denville, Morris Plains, and
Units
now
in
you
Morris
just mentioned
Plains
Hanover.
Will only,
So-
the units of Morris Plains will only help Morris Plains. We're going to need.
Well, that's why I said from a regional standpoint.
It does
please
from a
help us.
regional standpoint, but again, the way it works is they come up with a statewide need, a regional need, and then a municipal obligation. And so the regional needs get satisfied through the municipalities, meeting their needs, their requirements. And so, Parsippany is going to have to meet its need, whatever that number ultimately ends up being. And every town's different. I also represent Florham Park. Florham Park is also just about settled. I mean, it was settled and it's going to settle again, I think, on Monday night. But in Florham Park, there wasn't as nearly as big of a divergence between the Kinsey number and the e-consult number. And so when the Fair Share Housing Center was offering a discount, as they have to, 30% discount to Parsippany off of 21 or 2,400 units, still a lot of units. In Florham Park, that 30% discount got us close to what e-consult said Florham Park's number was. So that creates an environment where a settlement is easier, to achieve. Parsippany presents, a lot of challenge because of the divergence. First of all, the size of the Kinsey number and the disparity between the e-consult number and the Kinsey number, creates, additional significant challenges in Parsippany, which we're going to work through.
Yeah. I've been a resident of Parsippany for 51 years, and it's very distressing to hear that we may as well throw out our master plan. I worked on the darn thing. But that's what you're telling me. The courts are now the master plan.
Well, the courts are imposing, this obligation on Parsippany and other towns. And, right now, because we have immunity, Parsippany has the ability to try and figure out how to satisfy this obligation. If we were to lose immunity, then we would lose all control. And we want to be able to maintain control so that we can satisfy the obligation in a way that minimizes the impact on Parsippany, utilizing some of the tools that Ed and I talked about and some others to try and minimize the impact and work with developers in a negotiation in which we can further minimize impacts. I think you all want us to do that as opposed to just having a court say, okay, developers, you can build here, 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 and here, and Parsippany, and by extension, you all as citizens, lose your ability to participate in that process in a meaningful way.
Parsippany's population has stayed pretty status quo for the past few years. Are these figures based on, growth, or on the figures that we have today? I think our population's about 53,000.
Yeah, there are three general variables that go into this methodology, but again, you get experts and they're going to come up with different variations of that, and that's why we have a court who's going to decide, which expert, to believe. But the three basic variables are, income levels, vacant land, employment opportunities. Those are the three basic variables. That's why I said, congratulations, you're all wealthy, because the wealthier community, the more of an obligation you're going to have, the more vacant land that you have, the more of an obligation that you're going to have. The question was asked about Greystone. Now, Greystone may actually be vacant land in Parsippany, but it's not eligible to be developed upon. And so by using a vacant land adjustment, we're able to take whatever our number is and further reduce it, because we would argue, and I think successfully, that there isn't the vacant land in town to meet that obligation. Same thing with the Waterview site. Again, one of the reasons why we were so adamant about acquiring that 10.5 acres, that top piece, 10.5 acres, is because, that while it would be vacant land, it can't be used to calculate our number once we close on it. So, we can take a vacant land adjustment. I was giving you a worst case scenario for illustrative purposes. The point is that the obligation is, could very well be very significant. But I want you to know that we do have tools at our disposal, to reduce those numbers somewhat and to, again, mitigate the impacts of projects on the town.
Thank you.
John, if I can also say that we're also looking to the master plan as a guidance document, and that's something we can do, but at the same time, the courts are still challenging us to be creative when it comes to the master plan.
But is it being creative or being rezoning for a builder's profit? I feel no obligation to be sure a builder makes a profit on a building he built, and I'll use 202 as the example, because he can't rent it.
And we agree with you. Again, another challenge in Parsippany is you have an abundance of vacant office space here. And
But is that poor selling, poor salesmanship, or the market? Either way, why should Parsippany people have to stand the burden, if you will, of a rezoning situation?
And we're doing everything we can.
I'm not trying to exclude low-income housing. What I'm trying to say is that I think we better be darn careful where we put it.
Yep. Understood. Thank you very much.
Thank you.
Thanks. I am Rohit Parikh, 46 Springview Drive, Parsippany. And thanks, a good presentation. Thanks to Mayor to invite us. My question is about Mill Creek. That development I have seen, it is very big. Is it a residential, rental, or what type of big development is coming there?
It's a what they call a luxury rental project, which has become a project that is very much in vogue today throughout New Jersey and in Morris County. So when you think of apartments in Parsippany, you're going to think about Rutgers Village, you're going to think about Trivoli Gardens, you're going to think about apartments that were built, many, many decades ago. What's happened is that there is sort of a new housing type that has come in vogue, which they call luxury rental, which are renters by choice. They're very highly amenitized. There's gyms and pool tables and fancy fixtures and fit and finishes and pools and barbecues and things of that nature. And you can see those at Modera in Morristown. I negotiated that project on behalf of Morristown. And if you were to go on the website to Modera 44 in Morristown, you would sort of see exactly what I'm talking about. And my understanding is that's the type of project that they're building.
I have seen the big parking building also they are making. Is it only rental property?
Yeah, it's only rental. And usually what they do is they wrap the deck around the units so that you're parking on the same floor as your unit, and you can get out of your car and walk into the unit, and the parking along the highway acts as a sound barrier so that the noise doesn't affect you in your apartment. That's the concept.
Yeah, because I've seen little townhouses type things are there and small, so big development is there.
Yep.
And where is the UPS building is coming, as you are telling?
The UPS building is under construction, as I understand it. It's under construction, and we negotiated there a payment in lieu of taxes, and it was really, that was, there's a lot of tough news tonight. That was actually a really good one because Parsippany competed with Marietta, Georgia, to get this building built, and Parsippany won that competition. And I think it's really because the mayor assembled his team and got everybody together and working over the Christmas holiday with the UPS folks. And we negotiated a pilot with UPS in which Parsippany is going to get $332,000 a year. And we're really, really excited about that. And you should start realizing some of that money towards the end of this year. And next year, that's going to be $332,000 a year coming into the Parsippany coffers. So that's one that we're really, really happy about. Cherry Hill Road.
Cherry. Thank you.
Thank you.
I appreciated your commentary earlier about how we got to this point.
Thank you. Can you give your name?
Oh, I'm sorry. Arndt Thuen, Thuen, at 715 Mountain Way.
Great, thank you.
Yeah, so I just appreciated your commentary, explanation of your little sidebar, how we got to this point. Would you care to pontificate a little bit more about why the developers have so much control over the state Supreme Court? What is it that is prompting in your opinion?
Sure. Well, I don't think it's the developers. I think it's the housing advocates for people of low and moderate income means. You know, what the Supreme Court recognized when it created the builder's remedy in 1983 was the fact that in order to create the money necessary to provide low and moderate income housing, that you had to make that economically viable by having market rate units as well. And it's the creation of the market rate units that provides the economics that makes the affordable housing available. And that's a concept and a theory that the courts bought into in 1983, and they've maintained it ever since. And you know, so it wasn't so much developer driven, it was affordable housing driven, and it was to combat from the court's perspective the concept of exclusionary zoning, where again municipalities could zone in a way that made living in them by people of lower economic means unattainable. And you know, that was the origin of the doctrine.
I noticed that Mountain Way there was a lot of energy expended on the Mountain Way project for about 6-7 years, but I didn't see it on the map here, and I know this was an issue in that whole deliberation.
The Mountain Way project was not in our plan, but there was a settlement in which we were able to get COA credits on that project.
Yeah, we will be actually applying additional credits. There are other credits from that development that we will be applying to the...
Okay, and there is quite a bit of vacant land over there. I guess that's on your radar, right?
Yeah, there's environmental challenges over there as well, and even on that project, they still have to get their wastewater management, their permits from the state, which I don't know where they are in that process, but if they're able to achieve that, then we'll get additional COA credits for that project. But that came after our plan was submitted.
Okay.
But they'll be included in our plan going forward.
Yeah, they had, what, 20 units, 25, 30?
Yes, I don't recall, something like that.
It's over 20 units.
Okay. Is that a part, do you know if the apartment building is still on that site, on that plan? It seems like they've cleared out everything for the townhouses,
yes,
but they didn't make space for the apartment building.
It was a component of that plan.
Okay, so that's still on.
I unfortunately am not on the zoning board. That was a zoning board application.
Right.
But that was approved within the development.
All right.
Hi, Pat Venezia, 102 Brooklawn Drive. I'm trying to better understand the experts' opinions because eConsult and Dr. Kinsey are so far apart. And if I understood you correctly, Mr. Inglesino, it sounded like the Mercer County case that's currently being decided, experts had to contribute their estimates, like they had to file their expert opinion for every municipality in the state at that Mercer County trial. Is that correct?
So what happened in Mercer County, first of all, both experts have submitted statewide numbers and did so long before the Mercer County trial.
Okay, so that's just the total number for the state?
Yes, and those experts were both deposed in connection with that case, and those experts also testified at trial, and those experts were also subject to cross-examination at the trial. What I think you're referring to are the gap period numbers. So remember, the Mercer County trial is a two-part trial. Right. The first part of the trial is what is your third round prospective need obligation number, okay? The second part of the trial is what is the gap period number. Now, the gap period number is a new number, and because it's coming on the heels of the January Supreme Court decision of this year in which the court held that there is a gap period obligation. So Judge Jacobson ordered the experts to prepare reports as to what just the gap period obligation is based upon the Supreme Court's January decision. Those experts, it turns out, prepared gap period numbers not only for Mercer County, but they prepared those numbers for the entirety of the state, knowing of the interest throughout the state for those numbers. And so that is why I indicated that there were numbers, statewide numbers prepared in connection with that trial.
But these statewide numbers are just for the entire state. What I'm really trying to understand is Parsippany, like closer to home here, Parsippany, Florham Park, you said they just settled, to understand the reasoning behind, like, why does Florham Park have X number of requirement and Parsippany has Y number of they must have, the experts must have said the criteria, you were saying income, employment opportunities, and I was wondering if there was an opportunity for a citizen to be able to read the expert's opinion and see it somewhere. I tried to go up onto judiciary.state.newjersey.us to try to get the information, and I needed all this legal stuff like docket number, docket lawyer type, and all that.
Derek, we have the expert report. So if you email me, we will email you back both expert reports. We'll email you back the eConsult expert report, the Kinsey expert report, and we will also email you the most recent gap period reports prepared by both experts.
And that'll tell me their criteria?
Well, it's going to tell you the criteria. It's going to be very complicated. You need a PhD to really get through it, but I will send them to you.
Okay, thank you.
Okay? Actually, email Derek. You'll get them quicker. Anyone else have any other questions? All right. Well, thank you all very much for listening to this stuff. Appreciate the attention. And again, if you have any further questions, don't hesitate to email me. We'll get back
Just
back to you.
just in closing, I want to thank you for coming and your interest, because this is a situation that's going to affect everybody in Parsippany, and it's very important that you come out and Parsippany wants to be as transparent as we can with this situation that possibly could happen. But that being said, one of the reasons why I had the meeting, and several reasons, as the township attorney said, a lot of misinformation goes out. So you get to draw a conclusion on your own on misinformation. I didn't want that misinformation to affect. I dealt with this in 2013 with the Waterview site. A lot of misinformation went out with the Waterview site, and I wasn't going to let that happen again. We're in this together. We're going to do the best we can. We're going to fight as much as we can. I understand the concern of all the residents in Parsippany with this obligation that we have, that was draconian obligation that the Supreme Court puts on townships like Parsippany, Troy Hills. As you heard, the township attorney said that when you don't legislate in the legislative body in the state, these are the things that happen, and it falls on the governing bodies, governor's body in Parsippany, where sometimes we feel our hands are tied. You know me, if you know me, I'm a fighter. But sometimes, you have to sit back and say to yourself, okay, well, if I fight too hard, do I hurt you? And that's the last thing I want to do. I grew up in this town. I've been here since a baby. I've been here 50 years in Parsippany. I know the town like the back of my hand. I know most of the residents. But I can tell you this, we're going to be in this together. We're going to do the best that we can. And I want to thank you for coming out, because it really means a lot to me that you're concerned and stuff. And like the township attorney says, please, feel free to email him and any question that you have, because we want to answer all your questions. Thank you, and God bless you all.